All right, apologize for late start. We're going to call this to order. We'll do consideration and approval of minutes. Any questions on the comments, changes on the minutes? Moved by speaker to pass the minutes, second by Majority Leader Croft. Discussion? All those in favor say aye. Opposed, no. Minutes are adopted. We're now going to have a briefing from the Attorney General. I put him up first just out of respect for time on some recent litigation at CompSA, so welcome to the committee, General. Is your mic on? Just make sure that.
Now it is. Thank you, and thanks, members of the committee, for taking your time to hear a little bit about some recent developments in litigation. I'll cut straight to the chase. As you may be aware, earlier this summer, a group of states led by a coalition of Democrat attorneys general filed a lawsuit attempting to compel the Trump administration executive agencies, a collection of agencies, to deliver, to spend the remainder of federal grants that had been appropriated by Congress but had not been spent yet. Then on July 31st, that group of plaintiffs, the case is New Jersey versus OMB, Office of Management and Budget. Then on July 31st, just a couple weeks ago, Governor Kelly attempted to join and represent the state of Kansas in the lawsuit of New Jersey versus OMB. That suit, as I say, claims that the executive branch of the federal government doesn't have the authority to terminate these grants. It was filed in federal district court in the District of Massachusetts. Before she attempted to join this lawsuit representing the state of Kansas, Governor Kelly requested that I, as the Attorney General and Chief Law Enforcement Officer of the state of Kansas, she requested that I join the plaintiffs in this lawsuit and make the same claims. I declined after review by the attorneys in our agency because we believe that the lawsuit does not have merit. In other words, we believe that the plaintiff states will lose on their claim. So regardless of the relative virtues or necessities of receiving federal funds in any given area, it doesn't matter what the funds are. The legal claims that the states are making are not winners, and the states are going to lose in this case. Even if they do luck out with a favorable ruling from a particular district judge, as we've all heard in the news, there are district judges on every position on the political spectrum and judicial, ideological, jurisprudential spectrum, that when this case goes up on appeal, the states seeking the grants are going to lose. Earlier today, the state of Kansas filed, and you should have a copy in front of you, an amicus brief in federal district court in the District of Massachusetts in that case of New Jersey versus OMB. And in that brief, we informed the court that Governor Kelly lacks the authority to represent the state of Kansas in court, and consequently her actions attempting to represent the state of Kansas are in violation of Kansas law. Under Kansas law, only the Attorney General of the state can represent the state in federal court or in any court of appeals. And also in all litigation, in any court, including a state district court, which is the one remaining that I didn't mention just a moment ago, the Attorney General determines the position of the state. And that law has been in place since 1861. It's been modified by the legislature several times since 1861, but it has always kept the same core point, and that is that the Attorney General controls the litigation position of the state of Kansas. The Kansas Supreme Court has reviewed that statute, has interpreted it numerous times, and has pointed out that one of the primary purposes of the statute is to ensure that the state of Kansas always speaks with one voice when speaking in any court of law, whether it be in a federal court on some national issue or whether it be in state court on a very localized issue. And if you look at the brief, I think it's fair to say the brief is written in layman-friendly terms. I would urge you to look maybe at pages 3 to 6. Which outlines the Kansas statute that's involved. And the Kansas statute speaks very plainly on the subject that the Attorney General controls the litigation of the state of Kansas. So we have a duty to inform the Massachusetts federal court, especially a court when it's outside the state of Kansas and may have no familiarity with relevant Kansas law exactly what Kansas law says here, because otherwise the court might assume that a governor walking into a federal court might have the authority to represent the state in court. But under Kansas law, that is not the case. The governor's attorney attempts a little bit of sleight of hand in the lawsuit, claiming that, well, she only represents herself. But if she only represents herself, then she cannot make claims on behalf of the state of Kansas. And all of the alleged injuries in the lawsuit, financial injuries, are to the state of Kansas, not to the office of the governor. So by way of example, the governor could potentially represent herself, although even in that case, the attorney general would be the appropriate attorney, in a case where the federal government attempted to somehow infringe or take away the governor's ability to control the National Guard. That is something that the office of governor does control. But the financial interests of the state of Kansas are not, any injury to that is not an injury to the governor. It is an injury to the state of Kansas. So backing up, I mentioned earlier that we determined that the lawsuit was weak and would likely lose in federal court. There's basically three reasons why. The first one is sufficient in and of itself, and that is that there's a federal regulation at, for those of you who want to write it down, 2 CFR, which stands for Code of Federal Regulations 200.340 A14, or sorry, A4. And that gives all federal agencies the authority to terminate any award if it, quote, no longer effectuates agency priorities, end quote. That is what the Trump administration is relying on in terminating these grants because they no longer reflect the priorities of the new administration. The position taken by the states in this lawsuit is that those priorities are set forever in stone. So if an administration in the year 2020 asks Congress for money to fund a program and says these are the priorities, these are the reasons why we fund that program, then the states who are plaintiffs in the lawsuits claim that priorities can never change. But obviously, the priorities can change, especially when there's a transition in administration, and that's why the regulation is worded as no longer effectuates agency priorities. So their attempted reading of the statute is an untenable one, and it will not succeed in court in the end, regardless of what happens in the district court. Second reason is that under the Administrative Procedure Act, the APA, agencies are given discretion as to how to spend federal money, especially when it's in a lump sum, and an agency is under no obligation to spend every penny of money that was allocated to it by Congress. And then thirdly, under the United States Constitution, there's a background principle, of course, of the separation of powers. And although Congress controls the purse, and it is only Congress that can allocate the money, and Congress can put strings on money, the executive is the one who executes the award, and the executive cannot be compelled to spend unspent money. So for example, to take it out of the context of some of these grants, which really cover the waterfront on a host of topics, if the Department of Defense is request money for 100 new Apache helicopters and they decide, you know what, our priority is now to spend the money on some other armament, we only are going to build 20 new helicopters. Congress or a state that would be receiving perhaps the defense contract, or a base that would be receiving the helicopters, cannot sue a state representing where that base is located, cannot sue and say, no, you have to spend all of the money. The executive branch does have the authority to not spend appropriated funds. So that is a quick summary of why we believe the lawsuit didn't have merit and would not have merit regardless of what the expenditure is. So setting aside the merits of what the grants represent and what that federal money might do, we don't believe that any state has the ability to compel the federal agency to spend the money. And so purely on legal grounds, we rejected the governor's request and believe that that's not something the states have the power to do. And we would appreciate, a statement, since you guys are representing the legislature while it's not in session, a statement from the legislature on the topic. You don't have to, of course, but the governor is purporting to represent the state of Kansas and claiming that Kansas demands and wants the federal government to continue spending this money that these federal agencies have deemed to be unnecessary and wasteful. And it would be helpful, although not necessary, for the legislature to opine. And I'd be happy to answer any questions.
Committee questions for the general. Representative Woodard.
Thank you, Mr. Chair. Thank you, Mr. General. So I guess not an attorney, so I'll start with that. But looking over all of this, it sounds like the base of the issue that you have with this is that in the filing it says that the governor is joining this lawsuit in her official capacity. If it said in her personal capacity, would your office still have the same issue?
Well, she probably wouldn't be able to make the claim in her personal capacity. She would be saying then, as Laura Kelly, not as the governor of Kansas. So she needs to say official capacity to even begin to get her foot in the door. But she's saying in her capacity as the governor, in the office of governor.
Follow up if I can. So, okay. So I guess this is a learning opportunity for me at the same time that we're looking over this, but so we're not negating that the information that she's sharing, given her perceived negative impacts of what the federal government's doing. Your issue is just that she's part of the lawsuit representing the state of Kansas.
Right, that she doesn't have the authority to represent the state of Kansas in the lawsuit. And the other point I make is that this lawsuit is unlikely to succeed for those three reasons I mentioned.
Thank you. Thank you, Mr. Chair.
Further questions? Speaker Hawkins.
Thank you, Mr. President. This is in addition to what you've already talked about. As you may or may not know, I've had a couple of things out there about SNAP and the governor's refusal to adhere to USDA's request for information about our SNAP program. Our SNAP program is running at over a 12% error rate, which with the new big beautiful bill would cause us to have a pretty sizable amount of state share to pay. Actually, it's probably somewhere around 63 million because of the penalty of being too high. In your legal opinion as Attorney General, does she have the right to withhold that information from the USDA, and can she be compelled to give that information to the USDA?
So we have a team of attorneys investigating that exact question. I can say at this stage, however, that we do know that the provision of information is one of the terms under which the federal money is granted to the respective states. They have to provide information of this nature to the federal government. And so we certainly know that the federal government has the ability at this stage, if the governor continues to refuse to provide the information, to deny the funds. And I understand that that's a very substantial amount of money. We're talking about what was formerly called food stamps. And yeah, so she is putting at risk the receipt of Kansas of those monies, which I guess is sort of ironic and probably why you asked the question, because that is a very substantial amount of money.
Senator Sykes.
Thank you, Mr. Chair. Thank you for being here. So two questions. One, if you're convinced that we would have lost this and New Jersey is going to win, why would you not have joined on the OMB side?
Oh, well, that's a good question. So one option we had would be to join to try to intervene on behalf of defendants. But usually when you intervene, you have to have an interest that is not represented by the parties in a case, right? So all of us are sort of indirectly affected when there's a lawsuit like this of national consequence. But to be an intervener, we would have to say that there's something that the state of Kansas has that's at stake that the federal government, the U.S. Department of Justice cannot adequately represent. We might be able to make that argument, but it's not a slam dunk for sure. And one of the things that the plaintiffs would say, well, it's no skin off Kansas's back whether New Jersey gets the money or Massachusetts gets the money. And so how is Kansas hurt one way or the other by our having this lawsuit? So one option would have been to intervene, as you suggest, and then seek to move to dismiss Kansas. Another option, which is the one we chose, is to simply inform the court something that they probably don't know yet, and that is that in the state of Kansas, our law says that the governor cannot propose to represent the state of Kansas.
A follow-up question then. So do you support the cuts that are affecting Kansas?
We're taking no position on the cuts because, frankly, many of the cuts, well, the question of whether it's legal for the federal government to cut them is sort of separate from whether the cuts are desirable cuts, not desirable cuts. And I think, frankly, the political branch of government, which you all represent, whether Kansas money or federal money should be spent on these programs, it's ultimately for you to decide. But secondly, the suit itself is fairly unclear about what exactly, they give lots of examples of things that would be cut and have been cut. But then the suit gives a bunch of other examples, the complaint filed by the states in this case. The complaint gives other examples of the U.S. Department of Agriculture is spending $8 million, I'm using round numbers, on such and such a program. If this were to be cut, this would affect the state of New York in the following ways. So there are lots of hypotheticals where they say there's money out there that's not been cut yet, but if it were to be cut, that would be harmful. So there are relatively few examples of cuts that have already been made. So there's a lot of speculation going on as to what exactly, assuming that the lawsuit fails and the administration in Washington is able to cut everything it wants to cut from funds that have already been appropriated by Congress, which ones they would ultimately do, because we don't know that they would do every one that they can possibly do. So it's kind of hard to offer an opinion on all of the cuts, because we don't actually know what all the cuts are. We know what a few of them are, but we don't know what all of them will be.
I think just a comment, whether or not the cuts it's illegal, which side of that aisle you're on, but I think the fact that we're not fighting for those cuts is we are saying that we are complicit, and it will lead to cuts and have consequences for Kansas.
Well, I would simply say not necessarily. So let's say that, as you know, many programs are funded by both state and federal money. There's a state share and there's a federal share. So let's imagine a program where the federal share is 25% and the state share is 75%. If whatever federal agency under the Trump administration says, okay, we're cutting that one, it's not clear that the program would end, or that the state wouldn't say, okay, well, we'll use state dollars to pay for the remainder of those funds. So I think there's a lot of speculation in this lawsuit and about this lawsuit about exactly which programs would stop and which programs would not stop. Because in many cases, the state of Kansas, you all presumably would say, okay, this program is important enough, we would like to fill in the gap and keep the program going.
And I would say, though, that with all of the federal cuts that could possibly happen, we do not have the coffers to fulfill all of those.
Well, and presumably, and I'll let you all, address this question. There are some programs that, in the press coverage and in the public statements about this by the Trump administration and by other entities who are opposed to the cuts or in favor of the cuts, some of the cuts which are not given, front position in this lawsuit are ones that most people would say probably are not worthy. Those are programs that probably should not be continued because they go to very narrow interests, often in the DEI realm.
And I think that's where we have a team reading through some of that. You got $1 million grants for environmental justice and ag grants for socially disadvantaged. I think the administration is probably doing what it was voted in to do from some of that perspective. So that's where it comes down to policy, I suppose, on the legal merits. My question, I don't know, because since we're just talking about litigation, I know we're talking about this. Can you speak at all? There was some recent stuff on the Title IX stuff with our K-12 schools and some of that. Do you have any update on that?
The development this morning?
Yes.
Okay, so this morning, the U.S. Department of Education Office of Civil Rights announced that they would be investigating 4 school districts in Kansas. There's already been some news coverage of this and some public information presented by my office about this. We requested that the Office of Civil Rights investigate these 4 school districts because last year we issued a letter to a total of 6 school districts saying that your written policies, exclude from parents or conceal from parents information that the child and in school and the faculty members may have about the child transitioning to the opposite sex. And the policies of your school prohibit parents being informed of this. And that violates a number of federal statutes. It also violates the federal constitutional right of parents to be involved in and control the upbringing of their children. And that goes all the way back to a 1925 case of the Supreme Court. And it was just reiterated in 2025, about a month ago, by another case of the U.S. Supreme Court. And we pointed out to the school districts, hey, your policies seem to be in violation of state law. and the U.S. Constitution. 2 of the 6 school districts said, oh, thank you, we will change those policies. The remaining 4 said, no, we're not going to change. And so that's why we have pointed that out to the U.S. Department of Education. And the U.S. Department of Education, depending on how its investigation concludes, could withhold federal funds from those schools if they're violating either Title IX of the Civil Rights Act or FERPA, which is the Family Education Privacy Act.
Any questions on that one, committee?
And that just happened this morning, that they announced that. Our request was several weeks ago.
Appreciate that. It just strikes me that we're concerned about losing some of these DEI-style grants, but we're not concerned about our error rates inside of SNAP and what, the $63 million that could cost us. So, committee, is there any motions or action you want to take on this line item? Speaker Hawkins.
Thank you, Mr. President. My motion is going to be, I move that the Legislative Coordinating Council determine, number 1, that the Kansas Attorney General has the sole authority to represent Kansas in litigation. The governor's attempt to represent the interests of Kansas in New Jersey versus OMB is in violation of Kansas law. And number 2, second part, is the state of Kansas should not be a plaintiff in the lawsuit of New Jersey versus OMB, even if the Attorney General were representing Kansas. Doing so would not be in the state's interest.
Motion, is there a second? Second by Majority Leader Blasey. Discussion? Seeing none, all those in favor say aye.
Aye.
Opposed, no. You wish to be recorded? Okay. Record Sykes and Woodard. All right, thank you for coming. We're now going to move to item number 3, consideration and authorization for additional interim committees, topics, and meetings, and we'll go to Shirley.
Mr. Chair, you should have 2 letters in your packet. It's on? Sorry. You should have 2 letters in your packet. One is from Representative Delperdang on behalf of House Committee on Energy, Utilities, and Telecommunications, is requesting 4 days for an interim committee to examine statutes pertaining to telecommunications and the Video Competition Act. There is another letter from Senator Schallenberger asking for a special committee on pharmacy benefit managers and the 340B program.
All right, so committee, you have 2 requests in front of us. Do we have a motion? Speaker Hawkins.
Thank you, Mr. President. I have a motion to extend 2 days for the telecommunication, energy, utility, and telecommunications interim. I am not going to make a motion for the 340B or the PBM. And the reason for that is, go back to 2022. I worked for 2 years on a PBM bill. We finally finished it in 2022, the session of 2022. And at that time, then financial institutions and insurance senator from Lyon County basically said, we're not going to do another PBM bill for at least 4 years. We fought to get that one done. We had numerous interim studies and committee meetings on that issue. We did finally get that one done. To do another one right now, I think is, really useless, in my opinion. And quite frankly, most people know that I don't believe that 340Bs is a state position. It's a federal position, and it's a federal statute, and we're going to try to regulate a federal statute. If we're going to regulate that, we ought to regulate Medicare and everything else that the federal government tries to do. And so my motion is just for the utilities and telecommunications one, and also we also need 2 more days for the government, the House Select Committee on Government Oversight. That's my motion.
Motion, is there a second? Second by Croft. Is there a discussion? Senator Blasey.
Thank you, Mr. President. I think the discussion on 340B and pharmacy benefit managers warrants discussion because I believe while 340B is, in fact, yes, a federal law program. We've seen states all around us take action. I believe Missouri, Nebraska, Oklahoma have all adopted legislation, or at least have made big moves to address the issue that's at hand there. And the Kansas Senate passed a bill just this last session, 34-6 on this issue. So I think the Senate has a very strong position on the issue, and so I think it deserves attention and discussion. And so I will make a substitute motion to include the speaker's motion of those two other committees, but to add a special committee to study pharmacy benefit managers and the 340B program for 2 days, one to study each topic, with the Senate chairing the committee.
Oh, motion, is there a second? Second by Senator Sykes. Discussion on the substitute motion. Representative Woodard.
Thank you, Mr. President. I appreciate the substitute motion. For 4 of the 6 years I was on standing committees, I was on the insurance committee, and I feel like whenever it comes to anything regarding insurance or PBMs or pharma or pharmacies, we see a lot of finger pointing and not solutions-oriented thoughts. And so I think our interim committees are a really great opportunity for us to bring those parties together, have more discussion, more time where they're able to testify in front of everyone, bringing in all the different stakeholders. Everyone's able to make their case. And so I appreciate the substitute motion. And having worked at a federally qualified health center on the Missouri side after in a state that did expand Medicaid and did modernize their 340B program, I've seen firsthand the difference it can make. I don't think any state has the right solution regulating a federal program, but I think we owe it to our Kansans to see what we can do to make prescription costs a little more affordable. So I appreciate the substitute motion. Thank you.
So I've actually got a question for Gordon. What is a vote count on LCCs? They require 5.
Mr. Chairman, that's correct.
All right, further discussion. All those in favor say aye. Aye. Opposed, no.
No.
Motion fails. However, I will restate a motion that allows for a day for the 340B and PBMs, including the speaker's motion with the chairs determined by Speaker, the President, second by Woodard. Yeah, discussion. Yeah, division would have been 3-4, which would have been, I heard Croft and Hawkins say no. I joined them to make the 5 to make my substitute and still give a day. And I've now seconded by Woodard. Is there further discussion?
No, I forgot what I did.
It was to give a day. It was to give a day, both topics to be done. So I agree the topics need to be heard. Seeing no further discussion, all those in favor say aye. Opposed, no. Motion carries. We'll now move on to, I think that finished consideration of that. Consideration
So I have one more thing on that one.
Speaker Hawkins.
So we do have the select committee, House Select Committee on Government Oversight that's in the middle of some hearings right now. Probably the next hearing will be in September. And we need to be able to give them what's called compulsory powers, basically subpoena. The ability to compel a board or an agency to deliver certain information to them. So I'm going to move that the House of Representatives Select Committee on Government Oversight be authorized as an investigating committee of the House of Representatives and subject to the provisions of this motion to exercise the powers of compulsory powers pursuant to KSA 46-1004C1, the subject of inquiry, study, or investigation, and any issuance of subpoenas and subpoena duce tecum by the House of Representatives Select Committee on Government Oversight shall be approved by the Speaker of the House.
So I have a motion from the Speaker. Is there a second? Seconded by Representative Croft. Discussion. Senator Schallenberger.
How long does this last? I mean, is this,
They have one meeting left.
and so this.
One day.
This won't continue next year?
No, I have to ask for it again on the next one if we need
Okay,
it.
thank you.
Yep.
By the way, thank you for that clarity. I wasn't sure myself. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. We'll now move on to consideration of a notice of intention to dispose of a building for USD 220. Gordon.
Thank you, Mr. Chairman. You all have done this in the past. There's a statute that provides that when a school district wants to dispose of a school building, that the board has to submit notice of intention to do so to the legislature. Specifically, when the legislature is not in session, then the LCC takes responsibility. The notice is filed with the Secretary of the Senate and the Chief Clerk, and the LCC has, within 45 days, may exercise the statement that they deny their option pursuant to this section for the legislature to acquire the school building in question. And the result of your exercising that option or exercising a statement that you deny that option to purchase, that would allow the school district to proceed with the disposal of the building. If you were not to act, then the school district would not be able to dispose of the building till next session, depending upon the actions of the full legislature.
All right.
And
Questions?
indeed, the notice from, and the notice is in the packet, it's from USD 220 Ashland Schools, and that notice was timely received by the Chief Clerk and the Secretary.
Committee, do you have an action motion to allow disposition? Moved by the Speaker. Seconded by Dinah, or sorry, Senator Sykes. Discussion? Seeing none, all those in favor say aye. Aye. Opposed, no. Motion carries. Consideration authorization for printing of permanent Senate journals and House journals. We'll go to Corey. Corey Carnahan.
Thank you, Mr. Chairman. This agenda item is on the printing of the Senate and House permanent journals for 2025. Each year, the LCC sets both the price of the permanent journals and the number printed. This year, and in following the recommendation from prior years, the Chief Clerk and I are recommending 150 sets be printed at a price of $80 per set. And so if the LCC would like to proceed with the printing of the journals, we would just need that recommendation to be adopted. And I would stand for questions.
Any questions for Corey? Senator Schellenberger. Corey.
I don't know. The cost to print is a little over $30,000 per session. The proceeds from the sale of the journals is deposited in the state general fund. I don't know what the balance is.
Okay, thank you.
Further questions? Do I have a motion? Moved to authorize by Speaker Hawkins. Is there a second? What's that? Yeah, I need a second. Second by Representative Croft. Discussion? Seeing none, all those in favor say aye. Aye. Opposed, no. Motion carries. We're now ready for an update. Legislative Data Storage Center. We go to Tom.
Thank you, Mr. President. I'm Tom Day, Director of Legislative Services, and since I have the next three items, I figured that I'd just come to the podium.
Appreciate that.
Mr. President, the Information Services Office of the Legislature has been reviewing all of our systems, our hardware, our software, and removing as much duplication as possible over the course of time. I tried to bring a couple of the larger items up to the July meeting, and at that point we were running on a very short time frame, so it was suggested that we bring it to this meeting, the next meeting after the July meeting. We're in the process of finding and removing duplicate services and services items that need updated to help reduce total expenditures. In our ongoing effort it's vital that we seek approval for the council to move forward for a service that's required for continued day-to-day operation of the legislature and for the legislative staff. Our current data center will reach its end of life in October of 2025. This means our hardware won't support our new software updates needed for security and performance improvements. Additionally, vendor support for our software will end, leaving us without help on major issues, and extending vendor support could cost approximately $400,000 a year. We recommend moving our data center to Amazon Web Services. After looking at numerous cloud services, Amazon provides one of the best security standards, including FedRAMP compliance, multiple ISO standards, as well as SOC 2 certification, which exceed the state of Kansas ITEC policies and requirements. The cost of upgrading our on-site hardware, if the council so desired to do so, will cost us somewhere between $650,000 and $1.5 million, including the installation and operation setup. Amazon Web Services, on the other hand, will cost us between $176,000 and $245,000 for installation and operational setup. The current cooling system that's also in our data center in the basement of this building, in the sub-basement of this building, will also need to be replaced because it's on its last legs, and that could cost us another $90,000 to replace that. Mr. Chairman, Mr. President, at this point, I would ask that the Legislative Coordinating Council approve moving the data center services to a cloud environment with the Amazon Web Services and authorize the LCC chair to sign the appropriate and necessary paperwork.
Any questions for Tom? Seeing none, motion to approve. Got a motion to approve by Speaker Hawkins, seconded by Senator Schellenberger. Discussion? Seeing none, all those in favor say aye. Opposed, no. Motion carries. We'll now move to the KLS Modernization Project. Tom?
Thank you. Mr. Chairman, at the July 7th meeting of the Legislative Coordinating Council, the KLS Modernization Project Steering Committee brought forth informed the Legislative Coordinating Council that the production deployment of the KLS bill drafting system did not occur on June 30th, as we had planned. Basically because the required functionality was not yet ready. Additionally, the steering committee informed the LCC that they were working with the vendor to establish a firm deadline to have the bill drafting system deployed into production during the late summer, with a session-ready system deployed before October 1, 2025. However, during that meeting, there was discussion by the LCC members and directed the steering committee to work with the vendor to make significant progress towards having a session-ready system by September 2, 2025. Staff from the Revisor's Office and Application Services, and at this point I'm going to pause just a moment and make a little comment. Our IT staff and the Revisor's attorneys and also their administrative support staff have just been busting their tail ends in testing. And we have been testing regularly and often as each build comes in. We are expecting another build at the first of the week, during the first of the next week. But they have been continually testing, and I want to give my thanks to them. And I hope that the council will appreciate all of the work that the Revisor staff, the Revisor himself, as well as all of his staff attorneys and a lot of his administrative support staff in testing this new environment. So my kudos to them. And with that, Mr. Chairman, I just want to say that we've been working heavily with the vendor to meet that September 2 deadline and to go forward as we continue testing throughout the rest of this month.
Questions for Tom? Seeing none, we'll move on to update on the legislative CETO.
Finally, Mr. Chairman, as far as I'm concerned,
Me too.
Update on the legislative CETO process. I gave an update at the July meeting that the job was posted. and it was closing on July 25th. It did close on July 25th. We received 12 applications, and some in-house and numerous outside. We did not receive any international applications this time, as we did in 2019. But we do have 12 applications. Currently, the legislative post auditor, the legislative post audit, the revisor's office, the research office, and my office are evaluating those applications for to give the LCC subcommittee and LCC subcommittee on administration recommendations for interviews. Just a little bit of historical background. We had 12 applicants this time. 2024, we had 10 applicants. In 2017, we had 44 applications. Now, 2017, if you'll kind of put it in your head, was pre-COVID. And currently, because this is an on-premise position, it is not a remote work, it is not a work from home position. I don't know if that has anything to do with the big decline in applications, but I have this feeling that it possibly did, as well as in 2017, Payless Shoe Source was shutting down, and a lot of their computer staff were looking for positions as well. So just a little bit of historical background on that during the 2017 application process. At this point, Mr. Chairman, we should have the LCC Subcommittee on Administration, our interview recommendations, or recommendations for interviews, and I'm still waiting on a couple of the evaluations of the legislative agencies, the staff that are doing those evaluations, and then we will have them to the LCC Subcommittee on Administration. As well, in addition to those that we recommend, you will also see all of the applications.
Question for Tom. Senator Blasey.
Thank you, Mr. President. Tom, remind me, what was the annual salary for this position we posted?
As posted?
Correct.
We posted the position at $140,000 a year. That was based on what the previous CETO was making, in addition to a 5% increase.
Do you by chance know how much the CETO of the executive branch makes?
Of the executive branch, I don't know exactly what the CETO of the executive branch makes, but I believe it is a little bit over $200,000.
What about the judiciary branch?
The judiciary branch CETO is just under $200,000.
So the legislative branch is short at least 60 grand, roughly, from the other two branches of government, is what I'm hearing, roughly.
Compared to the other two CETOs, that'd be correct.
I think the legislature is way behind our fellow states across the country on technology. And I think it starts with getting a very qualified CETO. And so I'm going to make the motion to repost this position at a salary up to 100 and whatever the executive branch salary is, let's say $210,000. I don't know exactly what it is, but let's say up to $210,000 to be negotiated by the president and the speaker or the subcommittee. So I think if we repost at the higher wage, maybe we can get even more applicants or maybe more qualified applicants, because I think it's time that the legislature takes care of its own people like the executive branch and judiciary branch apparently has been doing. So that's my motion.
I got a motion. Is there a second? Second by Representative Croft. Discussion? Seeing none, all those in favor say aye. Those no. Motion carries. Looks like we're reposting. All right, thank you. Anything further come before the committee? I see none at the agenda, so we are adjourned.